Welcome to Agency Acquisitions and Exits. I'm your host, Peter Lang. Today I'm joined by Sharon Toerek, founder of Legal and Creative, a law firm that helps founders just like you in the marketing and creative space. Sharon advises agency owners on the legal foundations that are often the things that make or break deals. And we cover it on this session, so stay to the end, because at the very end, we cover AI and its implications in all matters of legal contracts with clients, employees, usage, and then, of course, when you're evaluating sellers and how you're using it in your evaluation from an M&A perspective. You do not want to undervalue IP, and in today's episode, we tell you why. Let's dive in. Sharon, thank you so much for joining me.
It's great to be here with you, Peter. Thanks for having me.
I was looking forward to this so much because in the world of M&A, you touch the things that are probably the most foggiest for founders who have never done it before, and even when they're approaching their own business. So please help us from where you sit. How does your firm have experience, and you specifically, helping creative agencies, agency owners with law and M&A and IP
Yeah.
and all the things?
Yeah. Well, first of all, I'm really happy to be here and happy to be talking about this because it's one of the areas of our practice where we can actually, I think, do a little bit better at persuading, if you will, agency owners, whether they're buying or selling, to be more proactive. Agency owners don't love to engage with legal unless they're
Really, Sharon?
unless it might surprise you to know that unless they're screaming into our DMs or our emails with something on fire, having to engage with the legal process or legal due diligence or just legal preventative measures is not something that's sexy about the business to them. But in this case, when you're looking at a transaction, whether buy or sell side owner of an agency, you can really move the needle from the perspective of a seller. Value recovery when you engage in the transaction from both parties' sides, how much money your professional fees are going to cost you during the transaction, and then how much time a transaction can take by being proactive in a number of areas. And so when agency owners think about it from that point of view, their ears perk up a little bit more and they're a little bit more willing to be preventative or proactive versus reactive and how they engage with the legal services that they need.
Yeah, it's so true. I'm a big fan of having people who have your back. And the people who have your back need to be professionals with extensive knowledge in areas that you don't. You're a founder, you're running the business, you care about servicing clients, recruiting talent and teams, supporting it with technology. You shouldn't be concerned with legal because you have someone like Sharon or you have someone that you trust who's got your back.
Mm.
And that's very freeing. Not like problem, red phone on the desk, Sharon gets a phone call, lawyer. It's the preemptive. So
Yeah.
let's go through kind of the key things in regards to things to prepare
Mhm.
that your firm helps people with that you've seen come up time and time again in transactions.
I like to get people thinking about these things as soon as possible. And ideally, the best time is a few years out from when you think you might be ready to engage in a transaction. And, coincidentally, the things we're going to talk about, Peter, are the same things that keep your agency strong on a day to day basis, anyhow, even if you change your mind and decide not to sell or buy in the future. And so I can share some experiences based on the transactions that we've handled and what helps, what saves time, what increases financial recovery. And they fall into a few categories. And I would say the first category is really the status of your contracts with the rest of the world as an agency. It would probably surprise people listening to this to hear that in many cases, they're in the middle of having a conversation, whether it's pre LOI or whether it's just, maybe interviewing brokers, and they have no idea where their client contracts are, when they expire, what sort of covenants might be in those agreements that they've made with their clients, especially their key clients, that could affect the transaction or the purchase price that they might realize in the transaction. So that is a starting point. It would be surprising probably to some people that, some of the longest term relationships that they've got in their client roster were handshake deals. We still see this, believe it or not, in 2026. And so, how assignable are those contracts going to be? What's the depth of the conversation you're going to need to have with those clients
Yep.
about transferring their business over to a buyer? All right, that's for the minority segment of contracts that aren't documented well. But for the ones that are on paper or that, have been negotiated and hammered out, are they assignable? What are their terms? How long? When do they roll over? When do they get renegotiated? You need to know this stuff if you're going to be credible in
Yep.
trying to value the book of business that you have. So that's the starting point.
So first order of business, if you're listening to this, is have a folder, digital folder, preferably with a spreadsheet, kind of like a resource catalog with all the current clients you have and past clients with their contracts.
Yeah.
How often do you find that contracts are inconsistent? So
All,
especially for a business that's like 5, 10 years, 15 years, 20 years in business, contracts evolve over time, right? They just get a little bit better. They have brought an attorney to work on a new one, but they have legacy contracts, they have out of date contracts. They're still active,
yeah.
but they just never kept them up. How often is that coming up? And
Not
from a
only
sell
that,
side and a buy?
all the time it happens, all the time. And also, most agencies book of business are a cocktail of client relationships that were documented on the agency's paperwork and client relationships that are documented via the client's procurement system. And so they had to use the brand's paperwork. And so there's a lot of dissimilarity. And this is not unusual for the average independent agency to have very dissimilar contract terms. Usually a lot of agencies are very good about maintaining some of their benchmarks, whether they've signed a contract a brand's put in front of them or whether they're using their own. And obviously, I have a point of view on what agencies should do and how they should handle that. But whatever you've done, the point is you need to know. Nobody likes the word audit, agencies especially, but
Assess.
you should be doing a periodic review, if you
Yeah.
prefer, or audit of your client agreements. Do it in real time when you sign the thing. What is the
Yeah.
term? What are the payment terms? What are the restrictive covenants? Is it assignable? Simple things that would impact the perception of the value of that piece of your book of business in a transaction.
We buyers, especially in business services, agencies are acquiring contracts, IP, and offering jobs if we're buying the assets and not the shares to the people who work there. So the material thing in a transaction are those contracts. From a buyer's perspective, how do you advise founders who are approaching, unsophisticated sellers to treat and approach these businesses that are unorganized with their contracts? Do you categorize it as risk? Do you think, can you work through that risk? How do you see it?
I think it should be characterized as a conversation. If a potential buying agency sees sees a spark of value in an acquisition target, there's some reason why that agency is appealing to them, right? Either there is a commonality of the industries that both agencies served, or the agency they've got their eyes on may have one key client that would be a really great feather in the cap of the acquiring agencies. There's a glimmer there of something that is a synergy between both agencies, or you wouldn't be interested in probably as an owner of an acquiring agency and speaking with them. So I think it starts with a healthy conversation. Once you have an NDA in place, so everybody's comfortable that they're not sharing information that could be used against them inappropriately in a competitive environment. Tell us about your best client relationships. How long have you worked with these folks? What is the integration of your team with the marketing people at those client brands? Get a sense for how healthy that agency's relationship with that client actually is. Then you can start digging a little deeper around the legal margins, if you will. Do you have a contract in place with them? And for how long is it going to be in place? And what was the negotiating process like when you went through it with them? There breadcrumbs that these kind of conversations can have that can help you and also shorten the pathway once you actually do get to due diligence if you decide to put an LOI on the table.
Many buyers are trying to flesh out in that instance, is the relationship with the client healthy enough to be worthy of a transaction, even if the contracts are what we just described as a state? Because you can still buy businesses who don't have those contracts buttoned up, as long as the relationships are strong with those accounts. They've been around for a long time. The delivery is predictable and consistent. When the buyer sees that contract mess exists, what do you typically advise the buyers to do with that type of seller? Clean it up first? Like, what's your advice about the process of kind of, not the Q of E, because that's a little bit too specific in due diligence, but in like their confidence with the opportunity? Because when you present a deal, you're presenting an offer, subject to due diligence. You don't want to retrade that offer. But the same token, you do want enough information to make a good offer and be confident that the business you're going to buy in the book of business is the thing you're going to get.
Yeah. Yeah. No, that's a great question. I am not a business valuator, so a valuator would answer this question probably in a very specific way about where to dig for clues about the profitability of that particular client, what proportion of the entire book of business is a particular contract bringing in, to the revenues of there are all those components of valuation that would be part of the conversation at this point. But from a legal point of view, what I would want to know advising someone who is acquiring an agency or having an acquisition discussion is, what was the negotiating process like with this client? What's your relationship like with them? Because I'd want to know, how much am I biting off in terms of maybe having to negotiate an assignment of this agreement if it's not papered well, or what was this brand like during the negotiating process? Were they reasonable? Did we have 10 layers of hell to go through with legal and procurement? And how amicable was that process? Because however amicable that process was or was not, will filter down into what the assignment process could be like.
Oh, yeah.
So,
it's a great predictor. Sure, that's great advice.
Yeah, I mean, you kind of want to
Even
know,
having great contracts that are assignable doesn't
do you want
predict. Yeah, it doesn't predict whether or not that client is going to be receptive to the buyer or the change of service. So, like, digging into that is so useful.
And I think that success certainly leaves clues, as they say. And so if they have a very long-standing relationship with this particular brand, that is a healthier sign that, well, it could be a healthy sign that the contract process was reasonable and well considered and fair-handed and even, or it could be a sign of the fact that it's a long-term handshake. And either way, you need to know as a buyer what you're dealing with, because you're going to need. It's not to say that if an agency that's a target of acquisition has not their ducks in a row with respect to their client agreements, then you should not consider them as a prospect. But you are going to have to do a little bit more hand-holding during the process, and due diligence might take longer, and your professional fees in the transaction are probably going to be higher. And ultimately, it could make a difference in the way you structure the deal or whether you're even willing to go forward with the deal.
Great. One of the things I do is I look at every interaction as due diligence, but I also don't mind when a seller takes the necessary steps to make the business slightly better that I'm buying. And so I'm all for, hey, your contracts aren't assignable. You don't have these things. Get them papered. Put these things in place without, signaling to the team or making a red flag to the client. But you got to get this in order for me.
Right.
I'd feel more comfortable moving forward with the terms that you have zero expectation if we can lock these things in. And so it's very helpful for them to do that. What happens, because I've had this, when a seller goes, Sharon, you're going to be the buyer in this role play. I have these client contracts, but I also have my reputation and my brand. I've been around for a very long time, 3 decades. There's value to that. And although that's a discussion around value, there is a way to secured those IP components prior to the discussion with a prospective buyer. And I think that's what you're flagging about coming early. Can we touch on that bit? Because
Yeah.
I hear that all the time about the things I've built, the way I do things, these things have value,
Yeah.
but they don't have the things that require identification of that value typically.
Yeah, and so we, have a pretty simple but effective rubric in these situations, looking at the intellectual property of an acquired agency, or an agency that is a target of acquisition. And so the book of business is one of the primary components and the most significant asset in many cases in a transaction like this. But other times, the intellectual property that the acquired agency has developed is equally and can be more valuable. It certainly can positively impact the valuation of the agency being bought. And so the rubric's pretty simple. We use our triangle analogy. It's brand, it's content, and it's transactions. And in this case, the what you just referenced about reputation, and I have a long-standing position in my client community as an agency. They know us well, they love us. We're well known for being excellent in this, that, or the other. That's all going to be reflected in brand to a great extent. And so you're going to want to look at, as a buyer, how well and how seriously has the agency being acquired attended to their brand? Have they protected their trademarks? Have they made a point to be consistent in their brand standards? Because the personal reputation of the founder of the agency that's being sold is a temporary thing once the transaction's closed, right? It's only going to get you so much leverage in the deal once you own that agency, because that selling owner is not going to stay around forever, nor do you probably want them to stay around forever, and maybe you don't want them to come at all. And so their reputation has to be reflected in some legal construct of how they've protected the brand of the agency, the entity itself as well. So that's brand. Then there's content, which is all the, I'll say, stuff, for lack of a more elegant term, but what sort of MO, methodologies, processes, and procedures do they actually have? Hard IP assets like like software, or a content library that is valuable to you and your client industry? And if so, what have they done to protect those things? Do they have relevant copyright protections where they need to have them? Have they maintained things as trade secrets where they are confidential and where copyright's not the right strategy to have protected them? Have they been serious and consistent about that? The more pattern of the better a pattern of consistency you see in protecting these components of the IP of the selling agency, the more valuable the agency, in my experience in handling these transactions. And so you want to look and see, is it a hot mess? Has nothing been protected? Have things been loosely guarded? Have there been blurred lines between the IP that the agency actually retains for itself and the IP that it does as, just a work for hire and lets any client have access to? You need to know these things. There's no right or wrong answer, but there's a right or wrong answer for you as a buyer.
Yeah, and we do purchase allocation based on this too. So
Right.
there's a good amount of goodwill in these kind of asset light or soft asset, digital asset type businesses. So if I were to be prescriptive, or you be more prescriptive, and say, what are the top things people typically can, when they come to your firm, secure with, contracts, trademarks, trade secrets, copyright? What are the things that are very typical for our sector?
So your client list is a piece of IP as well. And there you're going to want to look for your confidentiality is the key there. Those are trade secrets. And the key to keeping a trade secret protectable as a piece of IP is how closely you hold it and guard it. So how that shows up is in confidentiality and restrictive covenants in your employee agreements, in the agreements you have with your vendors or your contractors or your freelancers. And it shows up in the confidentiality language that you usually agree to in your client agreements. So that's your book of business, and it's a piece of IP as much as it's a working producing asset of revenue, right? You're going to want to look at how seriously if they have a prominent brand as an agency, what have they done to protect it? 10 other agencies that have the same name, in which case this may or may not be a deal breaker, probably isn't a deal breaker, but if the brand is being positioned as something of value and a component of the value of the agency you're buying, is there a trademark registration? Is there a portfolio of trademark registrations of the main brand, taglines, product names and services, service brand names and logos and things like that? Then let's talk about the actual soft IP, if you will, the content, the digital learning that they've created, the software code that they've created. Have they protected things properly with license agreements and with copyright registrations? Do they have adequate language with their third party contractors, freelancers about the ownership of all this stuff? Because if I'm going to sell you a piece of IP that I've paid somebody to create for me,
Yep.
I better have the rights to that in writing and in compliance with what the copyright law requires, or I can't really sell it to you. Or if I do, it's not going to be worth much money. Yeah.
And then also you have methodology kind of as the asset two of that content,
Yeah.
which is, I've come up with the steps or process we follow that we feel are unique to us, although
Mhm.
everything's kind of derivative work. For the founder who is, wanting to register this intellectual property, what is some of the reasons why they don't? Is it cost prohibitive? Is it they just don't know? Combination? Like what are some of the reasons they come to you and you're like, you haven't done it yet?
Yeah. I think it is history tells me I was an IP lawyer first before I started serving agencies in my career. And so my experience tells me that agencies are so wrapped up in the day-to-day of creating and strategizing for the benefit of their clients that it's just like the old adage about being cobbler's kids in terms of branding or marketing of the agency. So last thing you pay attention to as an agency, you're never your most important client.
Mhm.
Similarly, so it's a little bit of that, a lot of that probably. And also agencies tend to undervalue as a construct the fact that they are IP creators on a day-to-day basis. They just don't think of themselves that way. They think of themselves as creative, but not necessarily creators, because in the way, if you think about the way the industry developed, it was mostly creating stuff that the client was ultimately going to own. They weren't really leveraging their own unique secret sauce in repeatable ways,
Yeah.
50 years ago in the Mad Men days. And so I think agencies just don't think about how much they're leaving in the dusty corners of their offices that could be monetizable. And because they don't do that, once it's time to package an agency to sell, or once you're looking at the package that's being presented to you as a buyer, it's not accounted for in a way that moves the needle on the value of the potential business.
When a buyer shows up and doesn't want that IP, it can be carved out of the transaction. Maybe explain that, which is very helpful,
Yeah.
which in many respects allows you to continue the life of that IP in another form.
Yeah, this is a bit of a soapbox for me. I love to see agencies take and leverage their intellectual property and create additional streams of revenue and income. And the other reason I like that strategy, not only do I like it as a potential revenue play in the day to day of the agency's lifespan, but when it comes time to consider positioning your agency for sale, you might decide to sell the fee for service side of the business, the traditional agency side of the business, and keep the IP and maybe allow the buyer of the agency to have a license to use it. And we've helped a number of owners do this. They want to keep their IP and they maybe want to go out and consult, maybe to other agencies, maybe directly to brands, but it was founder created IP, or maybe it isn't, but the founder wants to take that and they don't want it to move with the book of client business. Sometimes you might want to sell the IP and keep the agency. We don't usually see it that way, but it's a possibility. It gives you options. And when you have options, the dollar signs get more compelling in my experience. And so doing this along the way, again, having that longer horizon that we were talking about, that several year horizon to get an agency ready to package itself for a transaction like this means that that lift is less heavy at the time that you're ready to go to market with the deal. And if you're a buyer, consider which parts or sides of the business are really of value to you or really best integrate into your existing operations. If you are looking mostly for a book of client business, the IP itself may not be as relevant to you. But if the IP is significant and a needle mover for you as an agency or your clients, then it's worth investing more money in as purchaser. So it's a huge side of the transaction. We have seen it move the needle on valuation, and we definitely see it give the principals of the selling agency more options when they are ready to execute our succession plan.
Yeah. And it's very buyer specific.
Yeah,
Strategic buyers who are absorbing the client book of business, they may not care about
right,
your methodology because they're going to deliver value the way they do it day to day.
right.
And you have, multi decades worth of IP that you've built that then in your next, I don't want to call it career because hopefully you sell but the next thing you spend your time
The
on,
next
you,
chapter, I
the
like to
next
call it the
chapter,
next chapter.
yeah, the next chapter, you don't have to start from scratch. You can leverage that. And a lot of folks who sell become advisors, become mentors back to the industry, and being able to extend the life cycle of that IP, of that knowledge, helps the industry continue to thrive too.
It's what contributes to thought leadership that drives
Yeah.
us all forward, right? And a lot of founders want the ability to either do that or they see a leverage opportunity with these IP assets to continue to create a revenue stream for themselves after they've sold the main part of the agency. And that's been folded into a buyer's business and their book of clients.
I'm an agency owner. I've even done acquisitions, but I've yet to approach the IP the way we're describing it today. What's the process look like to secure it? And how long does it take? Give me an expectation of what that looks like. Because say I want to take action immediately after listening to this. What am I doing?
So in today's landscape in terms of trademark protection, and that's the legal construct that protects the expressions of your brand, your names, your logos, the combinations thereof. From the time of filing to the time of final registration or decision at the Patent and Trademark Office, you need about a year. It wasn't always that long, but volume is heavy at the USPTO. And so the earliest you're probably going to get a resolution of a completed trademark registration is a year from filing. And that's assuming a really clean, clear process without a lot of questions from the examiner who's looking at the application, etc. You may also need to preliminarily do some trademark search and due diligence before you can even file. So then add a little bit of time for that. So the sooner the better in terms of trademarks. For copyright protectable assets, you're probably going to need about 6 to 8 months from the time you submit a copyright application. Copyright applications can be packaged to be about literary works, which is the actual visual presentation. That can be something like a workbook or a presentation deck or some key piece that is visual. It's a visual art or literary, like a book or a white paper, or it could be video. And so there's different ways. You can also package multiple works together in single applications sometimes. So you have to figure your strategy out, but that's a little bit faster. Licensing is a key opportunity that we see missed with certain assets that an agency wants to hold back because they use them to serve multiple clients. And you also want to be able to have that ownable and protectable as an agency. So That may be trade secret protection, so there's not a ton of lead time there, but you have to make sure you're accounting for owning that stuff in all the agreements that you enter into with clients or the rest of the world. And then I'll just round it out with, if you're an agency listening to this and you are not using a well crafted independent contractor agreement for anybody who is not a W 2 employee of your agency to help you create, you probably don't own the IP rights to that work, even if you've paid them for that work. You may have a license, but it's not what you want is ownership. And so, again, a lot of these things, as I said at the beginning of our conversation, this is just stuff that makes your agency stronger, regardless of whether you want to sell it or not. But these are things that matter when it comes to acquisition time.
Yeah, wonderful. The elephant in the room. Okay,
Mm.
I do this. Sure, and I get all my trademarks, my copyrights, and then I see my content being spit out by large language models. AI is showing up, and there's problems ahead of us, and there's disputes and lawsuits happening today. Let's talk AI. So, where do you think agencies are exposed legally right now?
I think a couple of things about that based on what we're seeing and the questions that we're getting from our agency clients right now. I think first that they're not accounting for the use of AI in the generative process of creating their work in their client agreements. And so that probably is a good indicator of the fact they're not having conversations with their clients about using AI to create deliverables.
Expand on that, 'cause that's very important.
Yeah. So if you are using any AI platform to help you generate deliverables for a client, whether it's creative work, whether it's copy, whether it is manipulation of data to develop strategy, there needs to be an accounting for that and your client service agreements for a couple of reasons. First of all, there needs to be a clear understanding on the client's part, primarily, that anything generated out of AI isn't ownable by you, the agency, them, the client, or anybody right now. This is the current position and state of copyright law in the United States. So let's put that out there plainly in the agreement, and let's make that reflective of the fact that we've had that conversation with our clients. Secondly, who's responsible if something goes sideways? If we as an agency inadvertently create something that infringes on some other party's copyright, which we didn't know about or do intentionally, who's going to be responsible for that? Because I can tell you that it won't be the AI platform. They're well indemnified, and read your T's and C's on all the LLMs.
You auto click check that box.
Yeah. They're fine with you owning any of the output. They're also not gonna indemnify you if there's any problems with any of the output. And so the agency and client have to have that conversation about how are we gonna allocate responsibility and liability. The other thing is you need as an agency to understand whether the client is putting any information in your hands as an agency that they don't want fed into an LLM, because the nightmare scenario is you feeding data, and I'm not even talking consumer data, although that happens too, and that's a nightmare in and of itself from a data privacy perspective. But just business intelligence. Here's some product launch plans we've got. Here's a new business strategy we may want to engage in, or a new market we may want to get in. You know, inputting any of that into an account that's not properly protectable as an enterprise, for example. And how this can happen easily is, oh, we're going to bring a freelancer in to help us with this project. And, they're moonlighting at home and using their own, Claude or Chat GPT accounts to feed data in and, create reports or
Yep.
strategy or whatever it might be. So, the examples go on and on. But the point is, who's going to be responsible for that breach of confidentiality if that
Yep.
information were to be misused in some way, shape, or form? So you need to be having those conversations. And how this is relevant, I think, to the marketplace is, I think you have good clues. Like I said, clues are important in this environment to how the agency being acquired has handled these issues and whether or not there's any landmines that you might be stepping into assuming some of this business or some of these projects as an acquiring agency.
Let's step further out.
Okay.
You're a prospective buyer and a target agency shares with you information under that NDA,
Mhm.
and you use AI to expedite your preliminary due diligence strategy or just your peer evaluation of the deal at various stages. It's becoming very flagrant and common for that to happen. Explain why that's a problem for the listener.
Well, the main reason it's a problem is because you're probably not complying with the NDA that you executed. You're feeding intelligence into an LLM or some AI powered platform that may not have the necessary safeguards against not using that in its training data, for example, or you are flat out not supposed to be doing that by the terms and conditions of the NDA that you entered into. And so, first and foremost, you're breaching the NDA. Secondly, you're using it to make business decisions that may not be completely contextual because you may not have the ability to feed everything into the prompts you are making.
My soapbox in that moment now, Sharon.
Well, we face this in the legal profession a lot.
Uh,
I mean, I don't mind clients using AI as a thinking partner to then come to us and ask us their questions. That's a great use case for it. What isn't constructive and what's not saving anybody time or money is using an AI platform to solve the problem and then sort of passing it over to your advisor for a quick check and a thumb up because that we can't do it. We can't do it responsibly. We can't do it ethically. If you're a lawyer, you can lose your ticket for not not using the proper
yeah.
protocol to give the client advice. But for the people listening to this, you're feeding information in without all the context that you actually need to make a smart decision based on the output that you get.
Yeah. My advice to the acquisitive owners is you don't want to farm out something that's going to make you so much better.
Yeah,
The ability to do the transaction is such a professional learning and development process. And yes, it's hard. Yes, there's a lot of data. And yes, with the right disclosures, you can use AI as a thinking partner.
right.
But you're dealing with sensitive business information. When a seller comes to you and says, "I want to sell my business. I haven't told anyone. I'm proprietary. This is not a go-to-market process." You have I don't call it fiduciary is the wrong classification. You have a responsibility. It's a legal responsibility to treat that information with the appropriate sensitivity. Never mind the confidentiality, just ethically in a transaction. And so the folks who are defaulting to using AI as a crutch, and I'll label it that, to help them progress deals, it needs to change. Now we're evolving and laws will shift and you can have disclosures and you can make it work. But I see it more as folks who are losing out on actually getting better because transactions can transform you, a buyer, and those parties who are involved. And you don't want to farm that out. Well, with AI, you touched on it, but I would love to just kind of give direct, specific direction. You refer to it as AI policies. Is that a correct way to think about it? Because you have it on the client side in the MSA, but
Yeah.
then you have it in your employment contracts, then you have it in your independent contractors. So are we talking about just an overarching AI policy that the company should have?
Yes, that's a great question. And one of the pillars of getting your agency AI ready, whether it's for a transaction or just in your day-to-day life of, growing the business is yes, the contract language that accounts for these scenarios is important. And we've talked through that. Having your AI policy internally as an agency and then your external facing policy that the client has access and exposure to is an important part of your risk management strategy with respect to AI. And, you know, in addition to that, you've got to socialize these things with your team. So it's great that you update your agreements to include AI specific language. It's great that somebody sits down and writes a policy. But these are conversations that need to be socialized amongst your team at the agency. And these are policies and language that need to be reflected in the critical conversations that you have with the clients, especially as soon as in the business development phase, sometimes of the relationship. And certainly, if you have a long-standing client and you execute a lot of different projects for them, you know, in front of the relevant project that you're going to be working on, because it's a constant dialogue and the tools are constantly evolving. Therefore, the safeguards need to evolve. The risk management is always going to be chasing the actual technology and then the business application of that technology. So it's a frequent check-in. It's not a set and forget. So it's dynamic.
Yeah, and from a jurisdiction perspective, a lot of our focus is on the US right now, just
Right.
from us talking about the treatment. But we have unique situations too. They're state level, and maybe touch on that because in an international landscape, you typically narrow or want to operate to the most conservative as a best practice. Explain why that is the case.
So, what's happening now in the United States, especially with AI regulation, reminds us a lot of what has happened with data privacy and the regulation of data privacy, with one key difference, which I'll explain in a second. Data privacy in the United States is regulated by a patchwork of state regulations. And the way that a marketer has had to deal with that or manage that in the US is by playing to the most conservative set of rules, which has traditionally been the California statutes. I will tell you that Maryland and Maine are starting to edge closely to, and as is Texas, believe it or not. And so that's been a reality for a while with data privacy, a frustrating reality for marketers and the agencies that serve them, as opposed to most of Europe, for example, which takes a very common approach through GDPR of how you govern data privacy. So move to AI and how AI is regulated or not regulated, as the case may be. And it's very similar in the United States. We are tackling it on a state by state basis or not tackling it. Um, but the twist there is this pressure from the federal government on the states to stay out of and away from regulating AI because they want a wider swath of control over how the AI industry is allowed to expand in our economy.
Yeah.
And I'm just stating facts. It's very plain, no matter what side of the fence you are on this issue. They want a common approach, and that approach could be do a lot or it could be do nothing or something in between. It's closer to do nothing as far as the federal government is concerned right now. Well, states are regulating aspects of AI in the meanwhile, primarily around the issue of having to disclose when you're using it to create marketing and or making certain that we're respectful of name, image, likeness rights by replicating voices and likenesses of humans using AI. So it's very similar, but the twist is that we have a federal government whose position right now in early 2026 is keep your hands off regulating AI. We would prefer to do it federally
Yet they're not,
that's going to
yeah,
be
whenever we get around to it.
whenever we decide it's appropriate.
Yeah, I think it's interesting, right? The way AI is being presented to society, it feels like the railroad. It feels like something that's going to be extremely difficult to justify state level controls, just like with cybersecurity and data center management. I think we have the Federal Railroad Administration, the FRA. I think we're going to have the Federal AI Administration. We're going to have something that needs to be a resource so it's not the Wild West, because the Wild West with a technology that is completely global today, it's global today, just doesn't seem like we're in a very strong position to protect ourselves, both as the contributor to the knowledge set and also as the user extracting knowledge from it. Do you have any predictions that we can hold you to in the future and make it?
Well, I will pat myself on the back for 1 second and say that on the copyright front, anyway, I mean, There's so many components to this, right? Data security, national security. But getting back to good old fashioned intellectual property, what I thought would happen around copyright is kind of the way it has played out so far. And what I mean by that is you've got what I'll call big AI, the major platforms, basically going out on a limb and saying, we are going to act and apologize later versus asking for permission when it comes to taking creative work or collections of intelligence, documented intelligence. We're going to take that stuff and we're going to import it and we're going to train off of it. If we're caught on the carpet about it, which they are being, there's multiplicities of cases around copyright infringement.
Yep.
Then we're going to enter into, we're probably going to resolve it by making deals with the copyright owners and licensing this stuff from them, because there's no way to keep us from actually taking it. But, you know, it'll be a better business decision for us if we're called on the carpet about it to actually figure out some system for compensating the original rights owners. And that's exactly what Anthropic has done. That is exactly what OpenAI has done. And we're seeing the first signs of it when some of the huge IP rights holders, like the Disneys, the APs of the world, actually sue these platforms for stealing
Yeah.
work or taking work. That's how I thought it would go down. That's so far how it has gone down. We will see what happens. What we haven't decided yet, and there's no Supreme Court cases on any of this yet. There's some appellate court decisions or some cases before the appellate courts. So we know that these platforms can't steal this work without responsibility, but we don't know what happens when the output infringes somebody's third party
Yeah.
third party rights in the original underlying work. We don't know if the platforms are going to be held responsible for that. And it's not an M&A issue, except to the extent that it should be reflected in the business practices of an agency you're looking to acquire. And for those of you who are looking to maybe sell down the road, start thinking now about how you're going to manage all this from a risk management point of view, and also how you're going to capture all of this in your contracts with the rest of the world.
I want to double tap on that closing statement, which is if I'm a buyer and I'm under LOI, I'm going through due diligence, and 27-person team that I'm looking to acquire with their book of accounts uses AI but doesn't have an AI policy in place.
That, if the question is, what should you do about that? Or what is that telling you? So what is that telling you? It's telling you that the target agency has not slowed down enough to document this, which could be a red flag that they haven't slowed down enough to check in with the team to make sure rules are being followed, that there's some sort of system for integrating AI into the workflow and the operations of the business. Ask a lot of questions. Buyer beware. Ask a lot of questions around AI policies and practices of the target agency. And then double down also on your audit and review of the contracts of the target agency, because
Where I want to make sure waving flag, Sharon. I'm like trying to make it like
Peter's waving a flag. Got it.
I'm waving a flag, soapbox level. I'm trying to put a megaphone to this. There's more businesses that do not have the prudent contract discipline you described, who are on the market today looking to sell, and buyers themselves who don't even have it.
Yeah. So here's what that means. That doesn't necessarily mean that the deal doesn't happen. It may very well mean the deal should not happen. It doesn't necessarily mean that the deal doesn't happen. Here's what it does mean, guaranteed. It's going to take longer. It's going to be more expensive in terms of your professional fees to sort through everything appropriately so that you understand the risk that you're taking on. And it could impact valuation, which matters to both parties, obviously. So this is why that matters. This is why understanding how the target agency handles an issue like this. And this is really just a magnifying glass on an issue that is contemporaneous with the times we're talking in. But we could have said the same thing about data privacy compliance, or we could have said the same thing about a lot of other issues too. But this leaves breadcrumbs to questions you should be asking and due diligence you should be doing during the
Yeah.
process.
I'll say it a slightly different way to double tap on it, which is how you do small things or one thing is a signal for how you do others.
Yeah.
And so it could represent a systemic oversight of negligence in other areas of the business, like could be cybersecurity, that
Right.
could be data management. There's a whole slew of things. And so it's important to pay attention to. And so what I would highly recommend to the listener, if you're approaching a business and you're hearing this for the first time, you button up day one, you figure out put on your mask first in regards to AI policies before you start going around and judging others. Second, if you're approaching targets and they have no AI embedded in any type of contract, whether it be with labor or client, suggest they get that done first. And that's what I think Sharon's referring to in regards to you can add more confirmatory due diligence so you feel better about the mess and uncertainty, or you can make it a cost that the seller should invest in
Right.
to make the asset better for them to transact. And that's my recommendation because I want to see the successful transition of businesses so both parties win.
Yeah, it's you fix the plumbing and put the new roof on before we take title. Yeah.
Sharon, this was incredibly useful because I know a lot of owners think legal work is just what you were referring to, defensive work, something they need when there's an emergency.
Yeah.
But what you've laid out is such an appropriate and important legal readiness to actually create value for these founders, both on the buy side and sell side. So not only does it protect profit, improves the options that they have, it gives founders leverage before they ever sit across from a buyer, and it gives buyers greater confidence when they're evaluating assets. So Sharon, thank you so much. If I'm listening to this and I want your help, how should I best reach out to you?
Well, it's been my pleasure, Peter. It's been a great conversation. I am active on LinkedIn, so it's Sharon Toerek, Toerek, and the firm is Toerek Law. We do business in the agency world as legal and creative, so legalandcreative.com. And my email is just Sharon at legalandcreative.com. So I always enjoy talking to agency folks who I haven't met yet. So if there's anything that I can do to sort of illuminate this process, always happy to have that conversation.
I appreciate you. You're the best, Sharon. Thank you.
Thanks, Peter.
If you like this episode, probably like one of our other episodes, click here.